In the event we have any connectivity issues, our staff will attempt to resolve those issues. If a party is disconnected, we will stop the hearing, take a recess, and attempt to resolve the problem. If we cannot get sufficient audio quality using Cisco Webex, we will attempt alternative methods, such as calling in to participate telephonically. For those of you who are participating via the video conference, because this oral hearing is being live streamed, please do not show any documents on the screen that might raise objections based on privacy or other concerns. For example, you do not want to show someone's private and confidential information online. And for the same reason, you do not want to use the Cisco Webex chat feature. Anything you transmit via that chat feature may appear online. Please state your name before you speak. This is especially important because some of our participants, including the appellant, is not able to see us. So please identify yourself each and every time before you speak. Please do not speak over each other. Please wait to be called on to speak. If by any chance you need to get the attention of the lead administrative law judge, you may interrupt, but please wait for the lead AOJ to acknowledge you before you start to speak. As mentioned previously, please mute your microphone when you are not speaking. This helps to avoid audio feedback. If you are speaking too fast, or if the stenographer is not able to understand you, the stenographer may interrupt you. Before we begin and before we go on the record, you will each have an opportunity to ask administrative and procedural questions. Mr. Navar, do you have any questions regarding the general information that I just discussed? Mr. Navar, you might still be on mute. Mr. Navar, we cannot hear you. Do you have any questions before we continue?
Yes, Navar, no question. No question. Can you hear me?
This is Judge Rosas. Yes, Mr. Navar, thank you very much. Mr. Working, do you have any questions before we proceed?
Brian Working, no questions from respondent.
Thank you. In that case, Ms. Alonso, we are now ready to go on the record. We are on the record in the matter of the appeal of J. Navar, OTA case number 1804-2970. This appeal was originally scheduled to take place in person in Cerritos, California, but because of COVID-19, it is being conducted virtually. It is July 23rd, 2020, and the time is approximately 1:17 p.m. The panel of administrative law judges includes Andrea Long, Jeffrey Margolis, and me, Alberto Rosas. And although I may be the lead AOJ for purposes of conducting this hearing, please know that this panel, the three of us, we are all equal participants and equal decision makers. I'm going to ask everyone to please state your names for the record. Mr. Navar, please state your full name.
Joel Navar. Joel Navar.
This is Judge Rosas. Thank you, Mr. Navar. And Mr. Working?
Brian Working.
This is Judge Rosas. Thank you, Mr. Working. As mentioned, the hearing is being recorded. We have a stenographer, so please remember to state your name each time before you speak. Remember to speak slowly, speak clearly, and to speak one at a time. A few housekeeping matters. We held a pre-hearing conference on July 2nd, 2020, which resulted in the issuance of 4 orders. I'm going to discuss those 4 orders now. Order 1 was appellants exhibits 1 through 7 were admitted into evidence without objection. Number 2, respondents exhibits A through G, Alpha through Golf, as well as exhibit J, Juliet, were admitted into evidence over appellant's objections. Number 3, appellant's objections to exhibits H, Hotel, and I, India, were sustained, and these 2 exhibits were not admitted into evidence. 4, The parties agreed to comply with specific time limits set forth for this hearing. Mr. Navar, is that an accurate summary of the pre-hearing conference orders?
Yes, I believe so.
This is Judge Rosas. Thank you, Mr. Navar. And Mr. Working?
Brian Working, yes, that is accurate. Thank you.
This is Judge Rosas. Thank you very much. One issue that came up during the pre-hearing conference, there was a disagreement between the parties in terms of the specific language of the first issue in dispute. I'm going to recite what my understanding is of the issue, but I'm going to let both of you chime in and restate that issue in your own words. Issue number one, whether respondent can establish that the proposed assessment based on estimated income was reasonable and rational, and if so, whether appellant can establish that the proposed assessment was erroneous. Mr. Navar, recall that you had a disagreement with that statement, so please, in your own words, no more than 20 to 30 seconds, please tell us what you believe is the first issue.
Thank you. The first issue will be proof, burden of proof. And that's the most, because I see something wrong, but it's for them to prove that it belongs to me.
This is Judge Rosas. Thank you very much. And Mr. Working, please feel free to chime in and discuss what you believe is the first issue to be decided.
Brian Working here. The first issue respondent feels is, has appellant met his burden to show error in the proposed assessment?
This is Judge Rosas. Thank you very much. In terms of issues 2 and 3, there was no disagreement between the parties. Issue 2 is whether there is reasonable cause to abate the failure to file penalty. And issue number 3, whether interest should be abated. Mr. Navar, is this your understanding of issues 2 and 3?
Yes.
This
again,
is Judge Rosas. This is Judge Rosas. Go ahead, Mr. Navar.
Thank you, Navar. It's related. It's arbitrarily or assumption, and that's a mistake against me for the status quo. And the burden of proof that should be or belongs to me, it's the burden of proof on them that that belongs to me and not a computer hearsay.
This is Judge Rosas. Thank you very much, Mr. Navar. You're diving into a little bit of argument. Please save it for your testimony and presentation. Mr. Working, is that your fair understanding in terms of issues 2 and 3 as I recited them?
Brian Working here. Yes, that is.
This is Judge Rosas. Thank you very much. Mr. Navar, we're going to move forward into your testimony and presentation. Mr. Navar, may you please raise your right hand? Mr. Navar,
Okay.
Are you raising your right hand?
Yes.
Mr. Navar, pardon the question, but I have to ask because I've seen this before. Mr. Navar, are you sure you're raising your right hand and not your left hand?
One question. Hold on. I have a question. I
Certainly.
decide not to testify, just go with the evidence that we have other than the open statement and maybe closing. The evidence submitted is the one that I like to apply or use, written evidence. So we'll make this shorter and faster. I sustain the same declaration that I made in writing.
This is Judge Rosas. Very well, as we discussed that at our pre-hearing conference, Mr. Navar, you have the option of just providing argument, which does not require you to take an oath, or you could be sworn as a witness. That way, the testimony that you provide may form the basis of a factual finding. But I did explain the difference between factual findings, between testimony, between argument. But as I understand it, you do not want to be sworn as a witness today, and you just want to present oral argument. Is that correct?
Yes, Judge, Your Honor, that's correct.
This is Judge Rosas. Thank you very much, Mr. Navar. In that case, as we discussed, you have a total of 30 minutes. Whatever time you do not use during your initial argument will be reserved for rebuttal. Please take your time and you may begin whenever you're ready.
Very well. Thank you all, and thank you, Your Honor. I'll make it brief, short, and simple. At least I'll try, and then we'll wrap it up sooner. On the opening, the evidence, not the evidence presented, would explain, it would show that this is a case where it's arbitrarily under presumption of the state and other people that this interest alleged being paid by me is beyond the proof of the state. It's mostly hearsay. I was able to find some evidence from other payers that did not belong to me. So it's like 3 items or 4 items according to the computer record, and that shows to be mine or supposed to be mine arbitrarily. I will the proof as I send on the writing, not automatically. There was a mistake, and the others I couldn't find the proof. I felt that something was not right, and that's why I continue and fight this case, for lack of better words. And that did not belong to me. Now, on the case of the evidence, the state doesn't have a sworn witness, live witness from Chase to present that belongs to me, and that is mortgage in this case. It could be credit card, and it could be for another family, but I couldn't find, for various things, the evidence. But it's the state proof or burden of proof that is mine. And they have the time to get a Chase representative where they can testify live and not hearsay or declaration. It could be a computer, and it's a hearsay. So I oppose to that. Give me 30 seconds to gather my thought. Okay. Secondly, it is more customary, and I feel it's more of a fraud from the state that they allege to me and they put the burden on me, and I'm the one who needs to tell them that it doesn't belong to me and the proof. And this is like when somebody said to another party, "You stole money. Prove me that you didn't steal my money." That doesn't. In reality, it doesn't work that way. When somebody claims you stole me and here is the evidence, and not hearsay or declaration, then it's questionable. So the same principle, I would think that it applies here. The computer might show, and they made a mistake on some of the interest being alleged, and the others could be the same position, the same situation. So I will ask that should not be the case or be applied in the same principle to me. And that will conclude my opening, and reserve the rest for the closing. I think I cover pretty much everything that I'm thinking of. Thank you.
This is Judge Rosas. Thank you very much, Mr. Navar. You reserved approximately 25 minutes for your rebuttal. At this point, I am going to turn it over to my co-panelists to see if either of them have any questions for you, Mr. Navar. I'm going to start with Judge Long. Judge Long, any questions?
This is Judge Long. No questions.
This is Judge Rosas. Thank you very much, Judge Long. Judge Margolis, do you have any questions? Judge Margolis, we are not able to hear you.
But I'll wait to ask. I'll ask my questions after the FTB makes its presentation, if you don't mind.
This is Judge Rosas. Of course, I do not mind, Judge Margolis. Thank you.
May I ask? Navar.
Mr. Navar, go ahead.
couldn't understand clear what Judge Mangola said, or if he can repeat the question.
This is Judge Rosas. Mr. Navar, Judge Margolis says he's going to wait and ask you questions later after the Franchise Tax Board has completed their presentation.
Very well, thank you.
This is Judge Rosas. Mr. Navar, I did have a few questions, but considering that you are not sworn in as a witness, the answers to these questions really wouldn't be helpful because my questions were more factual in nature. But I'm gonna wait to see if I have any questions for you after FTB completes their presentation. Thank you very much, Mr. Navar. At this point, we are going to turn it over to Mr. Working. Mr. Working, you have up to 10 minutes for your presentation. You may begin whenever you are ready.
Thank you. Brian Working here. Thank you, Judge Rosas. The issues in this case are: 1, has appellant met his burden to show error in the proposed assessment? 2, has appellant established reasonable cause to abate the delinquent filing penalty? And 3, has appellant established any basis for the abatement of interest? Appellant has not met his burden to show error because appellant has not filed a return or otherwise established his income for the taxable year. Although the initial burden is on respondent to establish that the assessment is based on a reasonable and rational estimate of appellant's income, once established, the assessment is presumed correct and the taxpayer bears the burden to show that the assessment is erroneous. The courts have held that if a taxpayer files no return or otherwise refuses to cooperate in the ascertainment of his income, the taxing agency may determine a reasonable and rational assessment based on statistical information rather than actual direct evidence of income. Where the government's deficiency determination rests on the reasonable inference that the taxpayers must have had sufficient income to support themselves for years when no income was reported and statistics are used to reconstruct income, the evidentiary foundation necessary for the presumption of correctness to attach is minimal. Here, in the absence of appellant filing his 2015 return, respondent estimated appellant's income based on the amount of mortgage interest he paid as reported on Federal Form 1098 and statistical data, the reasonable inference being that appellant's unreported income allowed appellant to maintain substantial principal and mortgage interest payments in addition to supporting himself. The statistical data is backwards looking and is comprised of income and mortgage interest data from all individuals who filed California returns and claimed a mortgage interest deduction on their Schedule A. The most recent study, Respondent's Exhibit J, was conducted in 2019 and compiled mortgage interest and income information from returns filed for tax years 2007 through 2016 and found the average total income to mortgage interest ratio was 10.13 to 1. As such, respondents' use of a 6 to 1 income to mortgage interest ratio provides a reasonable and rational, yet conservative estimate of appellant's unreported income. Accordingly, respondent's estimate of appellant's income based on the mortgage interest he paid is reasonable and rational, and the burden shifts to appellant to prove that the tax assessment is erroneous. It lay in appellant's power to prove his actual income and to controvert the statistics, but appellant has chosen not to do so. On numerous occasions, respondent has requested that appellant file his return to properly report his income, but appellant has refused. Accordingly, appellant has not met his burden to show error in the proposed deficiency assessment, and the assessment should be sustained. Regarding the delinquent filing penalty, appellant has made no arguments as to why he has failed to timely file his return, and as such has not established reasonable cause. And regarding interest, appellant has not argued or established any basis for the abatement of interest. Accordingly, based on the reasons articulated, Respondent respectfully requests that the OTA sustains its actions. Thank you.
This is Judge Rosas. Thank you very much, Mr. Working. I'm going to turn it over to my co-panelist, Judge Long. Do you have any questions for Mr. Working?
This is Judge Long. I have no questions.
This is Judge Rosas. Judge Margolis, do you have any questions for Mr. Working?
Yes, I do. Thank you. This is Judge Margolis. Mr. Working, I understand that that the Franchise Tax Board has reduced its proposed assessment in this matter. Is that correct?
That is correct.
And could you state on the record what the reduced amounts are?
Yeah, Brian Working here. The respondent has, based on additional evidence provided by appellant, respondent has determined that $22,172 of the original mortgage interest that was used to make the calculation was not paid by appellant. And so respondent has revised its estimation of income based on the mortgage interest paid of $16,126. So to make that estimation, we multiplied that $16,126 by 6, which gives you an estimated income of $96,756. We allowed an itemized deduction of $16,126, which gave a taxable income of $80,630. The tax, based on a single filing status of that taxable income, is $4,972, less an exemption credit of $109, makes a total tax of $4,863. Based on that revised total tax, the delinquent filing penalty would be $1,215.75, 25% of that total tax.
Okay. Thank you, This is Judge Margolis. Thank you, Mr. Working. I noticed in your brief you also found that appellant there was a 1099 information regarding a property sale by appellant for $500,000. Does that play into your deficiency computations at all?
At this time, respondent had not used that as a basis to estimate appellant's income. We relied on the mortgage interest information that we'd received from the federal government.
Okay, thank you. Now, I appreciate your providing the study that Mr. Navar kept asking for, the basis for your 6-to-1 ratio. I know we've had at the OTA lots of cases, and very rarely, I personally, I've never seen that study before, and I found it very interesting. But I appreciate Mr. Navar's comment that it doesn't really relate, may not relate to his situation, because when I read the study, what they looked at was interest on Schedule A properties. And from what I understand, you agree that Mr. Navar did not live at any of these properties. These were not Schedule A properties. This was not his home mortgage. So I'm just not sure whether or not the study, which is based upon Schedule A interest, applies here, because this would be, investment property or Schedule C property. I just want you to respond to that.
I believe Brian Working here. I believe the study is grabbing the returns of those individuals who have reported Schedule A deductions. But I believe they're looking at all mortgage interest deductions as it relates to total income reported on those returns. So that would include the mortgage interest that is reported from investment properties.
I couldn't tell that for sure from looking at the study. I really couldn't, to be honest with you. I mean, it doesn't, I know that when you're buying a house for your personal use, they look at whether or not you have a sufficient multiplier of the interest charge to pay off the mortgage. I'm not sure if they use the same standards when you're buying investment property, where you're going to have tenants to pay the rents. So I just, I do have a problem with the 6-to-1 ratio here, and I think that perhaps the property sale might be sufficient to validate what the FTB has done, but we don't know whether or not Mr. Navar had any gain on that. That's why I have a question for Mr. Navar. Mr. Navar, can you hear me? This is Judge Margolis.
Yes, Judge, I do. I can hear.
The FTB put in evidence, and it's been admitted, it's not hearsay for purposes of our consideration, showing that you sold a property for about $500,000 in, I believe it was January of the year in question. Do you, I guess, do you have any information that you can give us about, the basis, or what, whether or not that property was sold at a gain or a loss?
Right. No, I don't have any information on that.
Would it be possible for you to get it?
I probably can investigate and find out about that, but no, I don't have any right now.
Okay. Also, Mr. Navar, the evidence, although your prior year's tax returns were excluded from evidence, you did tell the FTB, the evidence is in the record, that you thought you had already filed for the year in question. So why were you unable to find your return, or why didn't you actually file?
Well, my belief is that I don't require, and they want me to accommodate, for lack of better terms, for them. And as the presentation of Mr. Bryant, if the way he accommodates, well, of course, has to accommodate, that makes sense, but doesn't pertain to me or doesn't fit to me. And I don't have that information, and I don't want to or can't. I don't have it all square to present something that is comfortable with. I am in the belief that as I argue several times, I'm not required to, and he's assuming that I am, and I'm supposed to convince them. So it wouldn't be on my part to prove anything.
Okay.
At the same time, it will be in the closing that the study that we've been talking about is rather bogus. It could fit for some people, but doesn't apply, especially in California. Even if that was the case, it's probably 3-to-1. Some other people are losing their properties, foreclosure, what have you. But as a general, it doesn't apply. I believe it's bogus, and they put the burden on me when it shouldn't be on me.
Okay, I have no further questions.
This is Judge Rosas. Thank you, Mr. Margolis. Mr. Working, I do have a few questions for you. Do you have the exhibit binder that was emailed to you last week? It's the one that was emailed to both parties.
Brian Working here. Yes, I do, Judge Rosas.
This is Judge Rosas. I have a question regarding Exhibit A, the IRS Wage and Income Transcript. I am looking at page 5 of 6. In reference to one of the JP Morgan Chase Bank mortgage interests, a one in the amount of $723. Now, I'm not a mathematician, but when I multiply that by 6, I get $4,338, which is slightly less than the $4,344 listed on the notice of proposed assessment. My question is, may you please explain this slight discrepancy?
Brian working here. I believe that is because of a rounding issue, that the amount of the 1098 reporting that $723 was it included something after the decimal point in amount of cents when multiplied by 6 results in the number that's reported on the NPA.
This is Judge Rosas. Thank you, Mr. Working. Mr. Working, the question regarding Exhibit 5. I realize this is not one of your exhibits. Exhibit 5, I'm looking at page 18 of 21. When you are there, may you please tell me what it is I'm looking at here? What is Exhibit 5, page 18?
Is Judge Brian working here? Is that the filing 2015 California filing requirement guidelines?
This is Judge Rosas. Give me 1 second. It is Exhibit 5, and in particular, it is not those guidelines. It is, well, let me ask you this. It contains, just for purposes of maintaining a clear record, on Exhibit 5, page 18, it contains some income record information. And there is a reference to an income record. The source is EDD, and the case amount is $115,449. And I'm wondering if you may perhaps be able to shed some light on this income record reference.
Sorry. I do not know where that income record was received.
This is Judge Rosas. I'm looking at the exhibit binder of all of the exhibits that were admitted into evidence, and I'm specifically looking at Exhibit 5, page 18. And give me 1 second, I can describe it, the top of that document for you.
Brian working here. May I interrupt, Judge Rosas?
This is Judge Rosas, please.
Brian working here. I am looking at exactly what you are looking at. I believe this amount may have been received. I'm not exactly certain of what this item of income represents. It appears that this would be wage income received by appellant in the amount of $115,449.
This is Judge Rosas. Thank you, Mr. Working. Mr. Navar, would you like to be heard on this matter in regards to that exhibit? It's your exhibit, Exhibit 5, page 18, and there's a reference to a source from the EDD, and there is a reference to a case amount in the sum of $115,449.
Yes. Yeah, those, if I understand correctly, I believe I heard that he's thinking that that's salary or employment or something. Is that what he's trying to say, Mr. Brian?
This is Judge Rosas.
Oh,
Mr. Working does not
I,
have the information to answer that specific question, so I'm going to give you an opportunity to be heard on this. I asked both sides the same question. It is your exhibit.
okay.
I'm just trying to ask if you can shed some light on that specific reference.
Okay. Yes, Navar. No, that's not employment or income or salary. None of that. I don't know what that is.
This is Judge Rosas. Thank you very much, Mr. Working, and thank you very much, Mr. Navar. Mr. Navar, at this point, I'm going to turn it back to you for your rebuttal. As I mentioned, you have plenty of time. You have up to 25 minutes if you so choose. Feel free to begin your rebuttal whenever you are ready.
Very well. Thank you. The state, Mr. Brian, again, Navar, the state was claiming or asking for me to show proof, and that the interest, assuming that belongs to me and absolutely, and not absolutely, but arbitrarily. And they had a chance to prove with the witness that a live witness from Chase, and they had the opportunity to subpoena and testify. So it could be a very mistake or just arbitrarily thinking that belongs to me, those amounts that were discussed. And he probably guessing that 115 has no explanation and assumed that it's employment or see what sticks. For the most part, it's hearsay, and it belongs to them for show the proof. Also, he was talking that I am the one who's supposed to show the error because they assume what they wanted to assume or they think, and that's unfair to me, and that I have to show reasonable cause not to be, not to be responsible for that. And he mentioned that I have to establish, and I didn't establish. My belief is that it's all established on the record, and nobody has the proof or the evidence, as he claimed, that it's supposed to be the fact. He's putting assumption over facts. And on the statistic, I keep asking for the statistic, and he liked that, and he wanted to apply, but that is statistic could be made by anybody. We can make a wrong statistic, and that throws everything off. That will be a bogus statistic. Maybe for many people might be, of course, might be that it applies, but not everybody. And as far as the proving, that I am supposed to prove, and I mentioned before, for the importance, that if my neighbor claims that I stole from him 100,000 or 10,000, and I have to prove that I didn't, and it doesn't go like that. Same principle applies to his claim because he got a transcript. For the most part, it could be a mistake, as he did at the very beginning for other mistakes that they made. Could be a credit card interest, or it could be anything else, but mortgage. So it's not the proof of me to find. I did try. I lost my wallet. I lost some information, and I couldn't trace some of the information. And I think he talked about the statistic or the study that they made from 2007 to 10. Every year changes. If I understand correctly, he was claiming that actually applied because that study was made in 2007 in cases in 2010, everything is changing. Even on this time and age, the world is changing every time and every day. And 1 second. As far as the tax assessment, that shall not be sustained. For opinions and concepts are not facts. It's not evidence. And my obligation to provide any information is each individual right to present, to give, to volunteer or not. Especially if we don't have the evidence, how can we produce one that we think is the right one? That's also incorrect for me or anybody in this situation. And I think that's the argument. Oh, the 115,000 that he's talking about is not a salary. I don't know what that is. Assumption that I received that amount. I don't know where that came from. I think that concludes my rebuttal.
This is Judge Rosas. Thank you very much, Mr. Navar. At this point, I'm going to open it up to questions from the panel. Judge Long, do you have questions of either party?
This is Judge Long. I have no questions.
This is Judge Rosas. Thank you very much, Judge Long. Judge Margolis, do you have any questions of either party?
No, I don't.
This is Judge Rosas. Thank you very much, Judge Margolis. Only have one question for you, Mr. Navar. I know that my colleague, Judge Margolis, in passing mentioned whether you wanted an opportunity to submit additional documentations regarding parcel of real property that was sold in 2015. Do you want to be granted that opportunity? If not, I'd rather be able to close the record and move on. But I'm going to give you the opportunity to chime in.
Thank you, Navar. No, I don't have anything to provide or say.
This is Judge Rosas. Thank you very much, Mr. Navar. Mr. Working, before we wrap up, is there anything else you'd like to add?
I do just want to make the comment that although appellant contends that this 6-to-1 mortgage interest ratio results when applied to the interest reported on a federal form 1098 does not represent his actual income. That may be the case, and respondent does recognize that, but that is why appellant, all the information rests with appellant for appellant to provide what his actual income is by filing a return. And for whatever reason, appellant has chosen not to do that to this day. No other comments from respondent.
This is Judge Rosas. Thank you very much, Mr. Working. Mr. Navar, you are the appellant, so I do want to give you the last and final word. Other than what you've already argued here today, and other than what you have already provided to us via your exhibits, is there anything else that you think this panel needs to know in order to make a well-informed decision?
Yes, I don't know if I do have, if this is the rebuttal and the closing, or I still have a different time, the closing, or it's all combined together? Closing and rebuttal is the same thing?
This is Judge Rosas. Yes, your rebuttal and your closing are the same thing, and we are in the process of wrapping this up. But again, I just want to give you the final word. If there's any last piece of information that you think this panel needs to know.
Navar, very well. In that case, I do have something else. What I can see here is that it's pretty much assumption and status quo and customary, not fact, not evidence. In my name, I felt that something is not right or fair. It's something is, despite personal issues and problems that doesn't come to play on this matter, it still exists. And the tax should not be assumed or even punished on the penalties and the interest while we clear these up. Even if the panel decide is dubious or what idea they might perceive, or what the fact that they can perceive, that puts me on a penalty for asking or for revising or checking my right numbers if I were to be responsible for some tax because I didn't couldn't get the number right. I still get punished on penalties and fees, which the first time to begin when I shouldn't be assessed. I don't. To this time, I still believe I am not qualified. Not that I'm qualified, but I don't need to file. And I don't need to make numbers to go with the flow. And I would ask the panel to consider all these opinions and not take them as a fact. And this should be not, let me find the word, not granted to the state or not punish me or not rule against me. And consider that the evidence the state could improve beyond only the assumptions and opinions for them and the analysis that they did. And most people might not check or investigate or appeal or fight, for lack of better words, again. And I happen to be in a different position. When I felt something was not right, I should at least ask and find out and defend my position. I hope that the panel will consider all these facts that were not facts and all what's presented. And I did try to work as best as I could, even with the state and with society in general, and with this hearing, and of course with me and my family. That will conclude in 1:30 seconds. Let me see if I'm missing something.
This is Judge Rosas. If you can make it quick, Mr. Navar.
Yes, very well. I am wrapping it up. All this will be, if it is a rule against me, it will be fraud and it will be bogus in my thinking, because the numbers were just made out and should be make me responsible without any facts or evidence well established and proven. Thank you. That will conclude.
This is Judge Rosas. Thank you very much, Mr. Navar. I want to thank both parties. That concludes the hearing in the appeal of J. Navar. The record is now closed and the matter is submitted as of today, July 23rd, 2020. Each party will receive our written decision, and we hope that we will issue that decision no later than 100 days from today. Thank you all very much. We are now off the record. The next matter should begin in approximately 10 to 15 minutes. Until then, we will stop the live stream and we will take a recess. Thank you very much.
Thank you.
Thank you all, Navar. Thanks for your help and service to all.